08, I did receive a second amended parenting plan from Miss McLean. And it was signed 11/9/23. Just want to make sure. Okay. I got two of them and I didn't know, but one of them was a proposed with a work schedule. And there's one with, the one I have has 2 pages of visitation rules as well, attached to it.
Yes.
Okay. Ms. Baldwin, we'll start
Thank
with you.
So if the court would turn to page 3 of the parenting plan, lines 12 and 13, it's talking about essentially having the evaluation from the tribe include collateral contact. And I'd ask the court remove, I think it's the start of the second sentence, the intent is for, and then capitalize the, so it would read the tribe, and then it said shall submit. The idea being that it's not sort of a nice goal to have, that the court did order him to have the evaluation with collateral contact. He can do it with the tribe, but it isn't sort of just a nicety. This is the order.
Any response?
Yeah, no, I guess I don't have any problem with that.
Okay.
So it'll say the Cowlitz tribe shall submit an update after receiving the collateral.
That's what
I take out the word to.
I just lined out intent is for the, so it says the Cowlitz tribe lined out to and interlineated shall. So the Cowlitz tribe shall submit an update after receiving that collateral information.
That's fine. And then up at C, just so it's clear, because under C1 is essentially the substance abuse portion, and C1 is substance abuse, C2 is domestic violence. So I would ask that the court just interlineate in up at C, right? That second line, it says substance abuse treatment, and if you just interlineated next to it, DV plus substance abuse. So it's sort of clear that we're talking about obligations for both, and then the subcategories are just the clarifications of what he has to do within those realms.
Any issue there?
I guess I would just suggest that it's a domestic or DV information treatment, since that's what was recommended.
I don't think that's what I disagree. That's what the report says.
Okay, so what I've done is I've just put an asterisk after abuse treatment, and I've added and domestic violence treatment as, and then recommended in his, and then added an S to evaluations.
Okay. And so looking at phase 2, I don't disagree with how council laid it out. It's just we're dealing with one of these just truly awful schedules that I don't want there to be confusion on either side. And so I'm asking that the court pen in language that it's based off of his regular schedule and not any other type of holidays or time off. So sometimes what happens is these folks will then take time off and they're like, oh, that creates an additional visitation. It's like, no, that wasn't the intention. The intention is just it's 4 on, 4 off. And that's the schedule we're using to create the visit schedule.
So in general, I would agree with counsel, although there are times when individuals will get a shift change and they'll put them on a completely different shift. And if he provides notice that here's the new shift calendar that I have, then they should be required to do that. I agree that he shouldn't be allowed to unilaterally change his schedule. That would be his choice to work around what his current visitation schedule is. But if his employer says you're now going to be on shift C instead of shift A, he has no control over that. And so long as he provides that updated shift schedule, then the party should be able to continue to work within those parameters.
And I disagree. That was essentially my second point. My second point is just that he have an obligation. Council's provided his schedule. I'm asking that he provide it on a monthly basis because to try to catch any changes. And to specifically pen in, sort of like you penned in the holidays below, that he would pen in, and these are the visits for this month. just so that everybody's clear. That, if there's any dispute, we address it up front and not like, oh, now you're not here and the visit's not happening. That provides both people clarity. And then you can add in, and if it changes otherwise, certainly a different shift schedule that should be accommodated. So I guess it would just, you could pen in, father's visits are based on the regularly occurring shift schedule. I'd ask that he provide it monthly along with the planned visit schedule. And that if there's a change, he then also has to update it. So I think that captures everything. And counsel, you can correct me, that kind of both of us said.
So we've already provided his work schedule through the first part of May of 2024. Why do we have to now provide it on a monthly basis? That just seems to me to be abusive and as an attempt to try and create an issue. If there's a question as far as what the visitation is, so what I did was I tried to lay out in paragraph 8 to A that it would be determined by where the father's first day lands. And then up above that, I indicated his first day off work shall be considered the day he comes off of graveyard shift. So it's clear. And if there's any question about that, I mean, right now, she can ask him or verify that those are the visitation days. And they're communicating through our family wizard. So I just think that the suggestion that we need additional language is a little bit of overkill. I do agree as far as him providing updates when there's changes.
The court looks like it's writing, so I'm not going to add anything.
This is, I think the schedule's been provided. So assuming no changes, I think he doesn't need to worry about providing a schedule until he gets the next, I don't know how many months in advance he gets it, but barring any changes. So what I've added to the end of the phase 2 paragraph before A is visitation is based on father's regularly occurring shift schedule. Any change to his schedule shall be relayed as soon as possible to the mother.
Okay. And then next is down below at section 10, dealing with Thanksgiving break and Christmas. This is not what I propose. I appreciate that I didn't clarify it maybe sufficiently. It's still even odd. Somebody gets Thanksgiving, somebody doesn't this year. Next year, the other person gets Thanksgiving. Sort of when you try to split the baby in this sense, no one ends up with the holiday, and that isn't reasonable. So I'd ask that this year my client be awarded Thanksgiving. Mr. will get it in even numbered years. On the Christmas holiday, I don't have any huge objection to the 2023 noon to 6. I'd ask the court eliminate New Year's Day. New Year's Day is not a child's holiday; it's a party day, and so that doesn't make any sense. I think that puts the child at more risk. And again, it's not a child's day. So Christmas is a reasonable holiday. New Year's Day isn't.
Well, I guess going backwards, I would disagree with counsel. There's a lot of child-focused events on New Year's Day. I believe that there's a walk around the lake that day. That's something that certainly that they could participate in. There's all sorts of different ways that you can celebrate New Year's. So if he has it off, he should be allowed to exercise that time. Normally, as we transition into a full holiday schedule, then it would be one parent would have the front half and the other parent would have the back half, which would include that New Year's Day, New Year's Eve schedule. In regards to Thanksgiving, he has that time off. We're asking that he be allowed to have Thanksgiving Day this year from noon to 6 p.m. She's going to have the balance of the break. And I would note that the court had only ordered as it related to 2023. The court did not make a determination of a holiday schedule moving forward. We've only talked specifically about these 2 vacations. I mean, if we're going to talk about holidays, there's Mother's Day, Father's Day, July 4th, Easter, a number of different things that should be considered. But you indicated we've got holidays coming up. We've got our settlement conference, I think, set in March. So you were addressing just these for 2023. Alternatively, if you're not going to give him Thanksgiving Day per se, then, and just bear with me because I'm I'm working off of the fly since I didn't have this information ahead of time. So Thanksgiving Day, is that the 23rd? Yeah, that's the 23rd. He also has, well, he works day shift on the 24th. So that's why we had asked for Thanksgiving Day, because he works day shift on the 24th. And it looks like, um, let me find here just one moment, please. So it looks like he works the 24th, 25th, 26th, and 27th.
So, but he would have already had under this schedule the 20th, 21st, and 22nd. So it's literally then my client gets, so he has those days off. He's getting from the 20th to the 20th or 6-hour visit, because that's where we're at currently. So again, it's like multiple visits within the same week. And again, noon to 6 is the holiday. That's when you're having dinner. So one person's getting it and one person isn't. But if you're doing that, then it's reasonable that it's clear, hey, he got it this year, the other person gets it next year.
Well, the court can decide, assuming you give it to him this year, since he has had such limited time anyway, the court can take that into consideration in determining what the future holiday schedule should look like. But the suggestion that she doesn't have the ability to exercise the rest of that weekend. I mean, families who are separated often schedule on different days for holidays. My client doesn't have the availability to do that, which brings up another question. And that is, so the court has allowed for those holidays, and typically those are family events. Is my client's family available, or can they be present for those holiday times with the child?
We've never said no to that. That was included in the restricted visitation schedule that council drafted. That's an easy fix.
That's not accurate, because currently my client had requested that his sister and brother-in-law be able to attend current visits since they live within the household, and that was a hard no by Ms. Wishart.
To not violate the order.
She had the ability to agree, and it was a hard no by Ms. Wishart. So then
I disagree. We forced these folks to sign something that said, I shall abide. That's actually probably a little bit more strong than a court order, because the parties have said, I'm promising that these are the rules I'm going to abide by, and I'm not going to deviate. So it's like, it's really boxing people in. Again, my client's not trying to be unreasonable here, and I'm happy that the court includes, hey, family on holidays. You bet. That makes sense.
So I'm keeping the proposal as presented by Ms. McLean, a limited period of time on Thanksgiving this year. And I agree, we have not nailed down all holidays. We discussed these because, well, I think we're all aware that things just take time, and it's probably good to address the 3 next big ones at this point. I'm going to leave it as is. I am perfectly fine, though, adding in a little notation that Mr. Wishart's family is can be present at all of those holiday visits, if that's
fine. That's agreed. Never has been a disagreement.
So then the question, well, I guess I'll move on. So then the other question is now that we've moved to 6-hour visits as all one visit, the question is whether the current order provides for sort of this rotation between Ms. Wishart's supervisor, which is Clay, her brother Clay, and then my client's parents. Clay will not agree to visits other than in a public location. And 6 hours and the weather changing makes it really difficult to do a visit in the park, or to spend 6 hours in a mall, or in a library, especially when we've got a young, busy child. So I guess the question is whether or not the court would consider providing for my client's family to provide the supervision moving forward. And then again, the question is with the aunt or my client's sister and brother-in-law who also live within the household, are they still required to be absent during those family visits or during his regular visitation?
So one, this is a direct reconsideration. The court made its ruling. It adopted phase 1 and phase 2, and we clarified with the guardian ad litem. Phase 1 is what they're doing now. Yes, was the answer. So we shouldn't be making modifications. Everybody needs to be reasonable with the visit locations, but that includes Mr. Wishart. If Mr. Wishart says my way or the highway, it's only at my location, that doesn't work either. So he has to be flexible that the indoor locations are not necessarily exactly where he wants it to be. Both parties have to be flexible. And again, that's just a direct reconsideration. On the aunt and uncle remaining in the home, I don't have any big issues with that, frankly. I think it's just how the visit supervision rules that are attached to this have been written. If the court wants to add a star to that and say, the aunt and uncle, it's somebody's home, they can be present. It's fine. I think that's reasonable. Again, these were not something that we really discussed. The visit rules were not something we've ever discussed directly. Something that I think council had created previous to this case, and so it's more of a boilerplate type thing. So I'm fine with family who owns the home can be present. That's not unreasonable. The idea that we're not that far from Mr. Wishart's last relapse, it's reasonable that both families still have some eyes on the situation until we get further into treatment and he graduates to phase 2.
Well, there hasn't been any negative comments about the sufficiency of the supervised visitation that my client's parents are performing. And clearly, they're still both providing supervised visitation notes for us. Obviously, in counsel's comment that she has no objection to homeowners being present, my client's sister and brother-in-law don't own his parents' home. And so just, I guess, if the intention is that normal residents within the residence can remain in the household during the visitation, we think that that would be appropriate. For whatever reason, Clay is unwilling to come into my client's home to supervise visits. The child has her bed, her toys, her clothing, things to do in that comfortable environment. He's been doing this since March of this year, I think, where he's having to go out into the community, and 6 hours is a long time, even for an adult within the community. So I guess as we're moving forward, and I agree that this is stuff that we didn't talk about at the time. We've still got a lot of moving parts when we're talking about what we're adopting and what we're not adopting. And so I mean, if I had to file a motion for reconsideration so the court can discuss or consider these real world working issues, then I'll do that. But it just seems to me that it's something that you could probably provide some way in at this juncture, given the number of times that you've seen this case.
And same, I mean, like the order is how council wrote it, and her own request is to change what we both understand what was ordered, without the ability for me to provide my client's input on, hey, that's not what's happening. We offer him X, Y, and Z locations, and he also says no, and sort of puts his foot down and is stubborn. So again, where we are, as the GAL said, keep doing what you're doing. That's what we should be doing, and that's what the order is as written.
Well, I guess the only comment that I'd say as far as the order is written is that the court had given us specific information. I tried to make those changes relative to your order so that I wasn't adding additional language for counsel to make the contrary argument, suggesting that I was adding things that weren't ordered. I chose to bring those to the court's attention now during the presentation.
We have Ms. Kale here. Ms. Kale, was your, if you don't mind weighing in, and I agree with Ms. Baldwin's rendition. What we're currently doing is what you're saying should happen. And I recall you saying yes. Was there any contemplation to expanding the visitors back to including Mr. Wishart's family during phase 1?
I see no issue with Mr. Wishart's family acting as supervisors. I understand the desire to have a fair situation where we have a supervisor from both sides of the family. I think I actually agreed with Ms. McLean stating that he's been doing this since March. He's done a really pretty great job, actually, of honoring all the requirements that have been put on him, so that he can demonstrate he's taking this seriously and that he wants to do well. I don't have any specific reason to say it has to be Clay and it has to be in a public setting and it has to be. I think that Mr. Wishard's family has done a pretty good job of paying attention to what's going on and honoring the rules and taking notes and trying to communicate the best that they can. The fairness issue, you know, that's something to take seriously, but I don't have any direct concerns about Mr. Wishard's family playing that role.
Thank you. Any questions for? Okay. Any other comments then?
If you were going to make those changes, it would be at, I've got to find it, paragraph, page 4, paragraph 8B1.
All right. The one concern I do have, I don't know in my recall offhand of the GAL report if these parties are in a better spot as far as communicating, but there was some, well, no, you needed to use my person this time. You can't use your person. There was a lot of that back and forth and disagreements. To avoid that, I don't know if every other visit it's Mr. Wishard's supervisor, Miss Wishard's supervisor. Is that something that we can agree to?
I haven't seen any issues with that for a while now. There were some initially, but that really died off when Your Honor was kind of like, no, it's
Okay.
supposed to have some evenness to it. So that seems to have worked itself out.
Your Honor, I can speak to that a little bit based on seeing the communication on Our Family Wizard. They've actually done a really good job. There have been some slight moments of contention, but they've worked through that and handled it pretty well, actually.
Good. I'm glad to hear that. So under AB1, it says, or another approved supervisor. I'm just going to asterisk that and include previously approved supervisors from Mr. Wishard's family. Okay.
I don't know what that means.
Yeah. Are you ordering us to keep doing what we're doing, or are you changing
No,
it?
there was already a group of people that were approved from Mr. Wishard's side of the family. So I'm going to reinstate those people. So the previously approved supervisors from Mr. Wishard's side of the family are included in the approved supervisors.
Okay, the only one that I can recall is Sierra.
Is she the only one that was willing from his side? Okay, so
She was the only one that was approved from his side.
okay, well then I'll just include her name. So what I've
Also,
done,
there's a gentleman by the name of Jack Slate. I want to say Slate or Slate. I believe he's from Mr. Wishard's list as well.
That's Ms. Wishard's father, I think.
Okay.
Or grandfather or something.
okay, so I've just asterisked after or another approved supervisor and just written Christina Wishard.
Okay. And so
So what's the court's intention with that?
I agree. I don't quite understand. I'm
Can
sorry.
we just pick from the 3? Or are you still?
They're working together. You just told me they work together to set up, so whomever's available, and hopefully it's relatively equal on both sides. So
Okay.
you were complaining that there wasn't an allowed supervisor from Mr. Wishard family. I'm giving you that request right now. So I don't know why there's confusion.
Sorry. Thank you. That clarifies it for both of us, and that answers every question. All right.
Was there something else, Ms. McLean?
So my client's parents already are approved supervisors.
I agree.
So, okay.
So if it's more than just Christina Wishard, that's why I wanted to say all previous. So if they're already included in your order, it only says, it only lists Lindbergh. Oh, it does list Jonathan Wishard's parents or another approved. So I added Christina Wishard. So that's everybody. Is that correct? That's willing and agreed upon.
Well, we had 2 others,
But they weren't agreed upon, right? At this point.
no, they were. I think Mr. Slate and I think there was one other, wasn't, but that's on her side, but
Okay.
But that's okay. That should, all other approved, that should work.
Yeah, if they were previously approved, then that's fine. I just added her in because I thought there was just one other, so.
so is it the
I have
Port
another
Prevention-
hearing here in 4 minutes, so.
My last one's short and should be agreed. Page
Sure.
6
Okay,
at 12B, the picking up parent and then dash the parent and just carry it in or designate.
I'm sorry, what?
the picking up parent who's about to start time or their designee, is that what you?
Yes, and any which way you want to put it in there. Around about
And
nine and 10.
after the dash where it says the parent who's about to start.
Yeah, so just making it clear that designees, it doesn't have to be the parents doing the exchange. You did
Yeah,
that
okay.
up at phase 1, just not at phase 2.
Okay.
So the picking up parent or their designee.
That's fine.
All right, anything else?
Just going back to that last one. So my clients, so anybody who's residing in my client's household may remain in the household during the visitation.
I think if they live there, I don't have any objection.
I don't have any problem with that either. I know on your visitation supervisor rules, it says, I understand third parties should generally not be present during visitation to ensure my attention is not diverted. No third party is allowed to observe, witness, or evaluate the child and the parent I am supervising unless arranged in advance and by agreement. That's only one that kind of concerned me with that, because I think if grandparents or aunt and uncle want to interact during visitations, I don't know that anybody has a problem with that. And I don't know that we necessarily strike that language under section 9, but I don't think there's any problem with the child interacting with other family members in the home.
Okay. So we can just rely on the clerk's notes to indicate that they may remain present during the visitation.
Yeah, I don't think the house needs to be evacuated before any visitation.
Okay. That's what's been happening. So,
Well, that doesn't have to happen anymore. Yes.
okay.
I'm
For that
gonna
clarification.
sign this, and Ms. Baldwin, are you okay to indicate approve via Zoom on your signature line?
Yes, Your Honor, thank you.
All right, I will, and Ms. Kell, are you good with that as well?
Yes, Your Honor. Thank you.
Okay, I will get this to the clerk, and I wish all the parties good luck and happy holidays. I don't know that we're on for anything before then, so good luck.
Thank you.